tables to figure out who their strikes are going to be. Once you've done that, that's when you have to ask, before they call names, you have to ask to reapproach the bench. And then you say, Judge, I have now exhausted all of my peremptory strikes. I move the court for 1 additional, 2 additional, 3 additional strikes. The judges will happily allow you to forget to do that if you forget to do that. Just make a big note on the top of your chart. If he's denied a strike for cause that you think was a good strike for cause, write a huge note in red letters, ask for additional peremptories. And you're going to have to reapproach to do that because you need to figure out who you're going to strike, and then circle the people that you would use those peremptories on if he gives them to you. That way, if he gives them to you, you knock them out, you've got your list. If he doesn't, while you're standing there, you can say, then Your Honor, in that case, well, actually, no. Well, I guess it could kind of get you there. You need to make a strategic decision about whether you want the state to know before the lists are finalized who else you would have stricken. Because if they go through and strike those people for you, then they've cured your error. You don't have anybody objectionable on the jury. But by the same token, one way to look at that is you've dictated who they use their peremptories on and get you where you want to be anyway. So maybe that's the way you want to handle it. But where most people that I have seen waive their good challenge to a denied strike for cause is they forget to ask for additional peremptories. Yes, sir.
When you're talking about trying to get a 3823.
Okay, so this is on the 3823 issue.
How would you adapt that to a Fifth Amendment where you want to qualify a jury, that client's Fifth Amendment?
With the example I used at the end. With the example I used at the end, where you get one of the jurors to imagine that he's on trial, and you ask him, if I was your lawyer and I told you not to testify, would you take my advice or not? And then from there, you need to bounce that back out to the whole group. Who agrees? Who would take my advice? Who doesn't agree? And then those are the people you need to talk to, because what you need to get out of them is a commitment that, and here's the thing, don't ask them to agree that if your client doesn't testify, they won't hold it against them, because that's not what you really want to know. What you really want to know is, even though they feel like they would testify, are they willing to give your client the same benefit of the doubt that they would give their neighbor who just said, I would follow my lawyer's advice and not testify?
But you can't get a jury charged on that Fifth Amendment like you can in 3823.
Well, if you're so are you asking how you get the juror qualified or how you get the instruction on it? Right. And I will tell you, I've won more 3823 cases with a properly qualified jury without an instruction than I have with the instruction. Because I've had plenty of cases where I had a good faith basis to do the 3823 voir dire. I got the jury I wanted, and ultimately the judge found that there was no disputed issue of fact. But as far as the jury was concerned, they weren't convinced that the cop was telling the truth. The other beautiful thing about this 3823 qualification is neither the prosecutor or the judge are going to stand up and say, no, 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 that's not the law. And so you're inoculating is not the right word. You're conditioning the jury that this is the law, and you're going to have a responsibility to say, at the end of the case, if you think that evidence was illegally collected, you have an obligation to ignore it. And so I've had a handful of cases where the judge in the charge conference denied the instruction. I argued that the cop was not telling the truth, and in talking to the jury afterward, they said we just weren't convinced he was telling the truth, so we didn't consider any of that stuff. So if you do the voir dire right, you don't need the instruction. Other questions? And on the Fifth Amendment stuff, if your client doesn't testify, you're entitled to an instruction on that. The Harris County Charge Bank language on that is actually one of the few places where it's pretty good, because it'll say, it's the defendant's privilege not to testify. You can't hold that against them. If one of your members brings this issue up, it is your duty to stop them immediately. If they persist, it is your duty to notify the judge. So they really put a fine point on it, but at the end of the day, in normal experience, if somebody refuses to tell you what's going on, that tells you all you need to know. And so you've got to get the jury to agree that that's not what's really happening here. What happened here is this guy's lawyer told him not to testify, and so he followed the advice. Any other questions? All right, well, my email is on the front of this. I'm always happy to help. You're welcome. Appreciate it. No problem. All right, let's just...
You want to turn this one off so everybody